Good afternoon. Welcome to the Appellate Division First Department. We have over 4 hours of requested argument time on today's calendar. So as I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time that you have been allotted, we will ask them and you will have an opportunity to answer. We've read your papers and are familiar with the issues that underlie your appeal. For those of you here for the first time, you should know that when the white light goes on the lectern, you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you are requesting. People versus Skeeter.
Respondent requests 5 minutes, Your Honor.
7 and 2 and 5. Global Leadership versus Commissioner of Finance.
Appellant 10 and 2, please.
Respondent 8 minutes.
7 and 2 and 5. Lauren v. Lauren.
Appellant 8-3, please. Respondent
I'm sorry, how much do you want?
8 and 3.
Thank you.
And respondent 8 and 3 as well.
Give you 8 and 2 and 8 and 2. People versus Kayane is submitted. Park 56 versus Board of Managers, Park of Vendôme. You don't have a cross appeal, counsel.
15 minutes, Your Honor.
Okay, 8 and 2, 3 and 1, Ms. Davis, and 7. People versus Cook, submitted. People versus Nieves.
Appellant requests 5 and 2. Respondent requests
5 and 2 and 4. Deutsche Bank versus Equifirst.
Good afternoon, Your Honor. For the appellant, this morning, the parties have filed an emergency application to adjourn the oral argument. This morning, we reached a settlement in principle, subject to mutually agreeable documentation. And so we requested that the appeal be adjourned to the September calendar, which we understand is the next available term, to allow us time to document the agreement. And anticipate moving back to the court within a week or two.
Counsel, who do you represent?
Deutsche Bank National Trust.
And counsel.
We represent Barclays and Equifirst Corporation.
Okay, well, Mazel Tov, your adjournment is granted. Kazantzis versus Cascade Funding. Looks like you have no opponent, counsel. Do you want to submit? If you want to highlight, you can. I'm sorry? I'll give you 3 minutes. Pearlbinder Holdings versus Patel.
Appellants 8 and 3, Your Honor. Respondent 5, Your Honor.
I'll give you 5 and 1 and 3. Hidalgo versus Hodge is submitted. Weissman versus Ravel Transit is submitted. First case, People versus Alfonso Skeeter. Please.
Good afternoon, Your Honors. Victorian Wu, Office of the Appellate Defender for Alfonso Skeeter. The incident in this case happened very quickly and was over in the span of just 20 to 30 seconds. There is no dispute that during this time, Mr. Rosello used deadly force against Mr. Skeeter by firing approximately 10 shots toward him. The limited evidence that the prosecution presented at trial did not disprove the defense of justification beyond a reasonable doubt.
Even though Mr. Rosselló was struck in the back,
Yes, Your Honor.
all of the shots that impacted him were to his back of the thigh, and his back. So
That's correct, and that's because there were 20 shots approximately that were exchanged, and the prosecution never identified which two of the 20 shots were the ones that struck Mr. Rosello in the back.
other than Mr. Skeeter, is there anyone else that was actually shooting at Mr. Rosselló?
No, Mr. Skeeter was the other shooter aside from Mr. Rosello at the scene of the incident, yes.
Okay, so then if he's the one that is shooting and Mr. Rosselló is struck in the back, then the bullets that struck him must have come from the gun that Mr. Skeeter operated.
That's correct, but again, the defense here was justification, and the evidence plainly supported the inference that Mr. Rosello had fired first or threatened the use of deadly force first before Mr. Skeeter used the gun. So again,
what evidence suggests that?
the evidence here, to begin, shows that Mr. Rosello was a person who instigated the fight with Mr. Colon and Mr. Washington. He was the first
But it was
person.
the defendant that ran towards that fight.
Right, but again, the Court of Appeals has clarified that the duty to retreat does not arise until the defendant sees the imminent use of deadly force.
At that point, we're not really focusing on the duty to retreat more so than we're focusing on who's the primary aggressor.
Correct, and the evidence here, and the trial court agreed in granting a justification charge that there was a very reasonable view of evidence that Mr. Rosello was the initial aggressor. He was the first person on the scene to brandish a gun, the Glock 23, and when Mr. Skeeter, Mr. Colon, and others on the scene saw the gun, the video plainly shows that they all retreated back to the sidewalk, crouched behind cars. Mr. Rosello then went across the street, fired 10 shots in the direction of Mr. Skeeter, Mr. Colon, and everyone else, and at that point, Mr. Skeeter then fired in response to that. And the question then is whether the prosecution disproved the proffered defense of justification beyond a reasonable doubt on this record.
Would defendant have been justified in firing while the victim was running away?
Mr. Rosello did move in the direction of the other street, but he also discharged 10 shots during that time. So he was not simply just running away, he was also exercising deadly force against Mr. Skeeter and the others on the other side.
Is it your contention that he was firing as he was running away?
Yes, and I think People's Exhibit 8, which was a diagram of the crime scene area, showed that the shell casings that were discharged or that came from Mr. Rosello's gun spanned a fair amount of the sidewalk where Mr. Rosello was running. So it is clear that as he was moving in that direction, he was firing from his gun. I don't think the people's contention, either at trial or here, was that Mr. Rosello stood still at one point and then fired 10 shots all at once. I think the evidence showed rather that as he was moving in that direction, he was also discharging his weapon. And
Counsel, could the jury have drawn the inference that Mr. Rosello was the aggressor? If he was the aggressor, he would have shot at Mr. Colon and Mr. Washington in front of the deli, which he did not do.
again, I think the question is whether at that juncture he threatened the use of deadly force, just warranting the protective measures that Mr. Skeeter undertook. So while it is true that he did not fire shots immediately when he was in the deli, but rather after he crossed the street, again, you can tell from the response of Mr. Skeeter and others who were running away back to the sidewalk, crouching behind the cars, that they plainly feared and reasonably feared that Mr. Rosello was about to use his gun, which he in fact did afterwards by discharging 10 shots from his firearm. So again, this is a case where the burden was on the prosecution to disprove the defense of justification beyond a reasonable doubt. It was not sufficient to show that Mr. Skeeter probably was not justified. They had to disprove that defense, again, to the highest degree of beyond a reasonable doubt. And I think on this record, given the very limited and incomplete evidence that the prosecution presented at trial, they simply did not discharge that burden.
Does the fact that Mr. Rosselló grabbed a pistol from Ms. Valentin's bag factor in any way with respect to your argument?
It does, because again, he was as between Mr. Skeeter and Mr. Rosello was actually the first one to get his hand on a gun, and he brandished it, causing other people who were there to retreat, go back from the street and crouch behind cars. They all understood that he was threatening the use of deadly force. There's no permissible inference other than that. So that plainly demonstrates that Mr. Rosello was the one who was the initial aggressor in this instance, and Mr. Skeeter's response was justified under the circumstances of this case.
Now, he didn't fire the weapon immediately as from retrieving it from Miss Valentine. He brandished the weapon to get the others that were running towards him to back away.
Well, we don't know what his intention was because Ms. Valentine didn't testify what his intention was when he pulled out the gun. And again, I think the inference is fair that when the others on the scene saw him taking out the gun, he was threatening the use of deadly force. And the law permits, you don't have to be shot first in order to exercise force to defend yourself or anyone else. So again, I think the prosecution in this case, given the circumstances at issue here, did not disprove the defense of justification beyond a reasonable doubt. And if I may, I want to address briefly the excessive sentence point. If this court does not reverse the conviction as against the weight of the evidence, the sentence of 20 years in this case should be reduced in the interest of justice. Prior to trial, the prosecution offered a plea of 15 years, and there has been no real explanation as to why a sentence of 20 years is warranted in light of the prior plea offer of 15 years.
Thank you, counsel. You can expand on that if you wish on rebuttal.
Thank you very much.
May it please the court, Matthew White for the people. The jury's verdict was fully consistent with the evidence.
Counsel, is it fair to say that none of the videos reveal who shot the first shot?
Yes, that is fair to say. There's actually no video of Mr. Rosello
Ms.
shooting.
Valentine also said, I don't know who fired the first shot, correct?
That is correct, yes.
So how could the people carry their burden?
The people carried their burden in several ways. First, as the court has noted, Raymond Rosello was shot in the back as he was running away. And this was proved by the autopsy, the videos, the testimony, the pictures.
Is it your position that, well, I just questioned your adversary. Your adversary said it's their position that he was firing as he was retreating, running away. Do you have a different take?
Well, I don't see how you could sort of be firing and running away and still get shot in the back. I think it's almost physically impossible. The video showed...
Was there any evidence or testimony to that regard by anyone?
I mean, there's no video evidence of Rosello firing, although he obviously did, because his shell casings were found across the street, halfway down the block. So that's when he returned fire. By contrast, all the defendants' shell casings are found where the initial physical altercation occurred. And as the court has noted, if Mr. Rosello had wanted to use the gun and wanted to kill any of the participants, he had an opportunity to do it. But
do
he
you
didn't
have
do
any
that.
witnesses?
He fled.
Do you have any witnesses that saw him running away?
It's on video that he's running away. It's undisputed that he's running away. And in fact, the video shows that as he's running away, the defendant and the group that he's with, they're not taking cover, right? They're not taking cover at that point. That shows that there's no threat there, that they don't perceive any threat from Mr. Rosello. And when defendant is firing, again, the group that he's with is mostly just standing around. And then about 10, 12 seconds later, they all take cover, and presumably because that's when Mr. Rosello is firing. You know, and this was sort of, it was a quick incident, right? And it starts in this deli where Mr. Rosello had a verbal conflict with someone named Sam Colon. And then when they go outside, Colon gives a signal, right? And that's the signal that triggers the attack, right? The video then shows that the defendant answered the call and ran to the deli with about 5 or 6 others from a block away. And the video also showed Rosello, by contrast, leave. He knew he was about to be attacked, but rather than use the gun he had, he tried to go home a block and a half away. And again, Rosello could have shot at that time, but he left. And the video shows that the person that the defendant and Colon were with, Washington, reaches into a garbage can at the corner, fishes out the community gun.
Counsel, don't we know that Mr. Rosello had a gun in his possession before Mr. Skeeter? Don't we know that?
We do, yes. But he didn't use it. He didn't use it. That's the point.
Do we know if he used it or not before Mr. Skeeter used his gun?
We know, yes, because
How do we know?
the shell casings in the video and the fact that he shot in the back and running away.
Does the video show who shot first?
The video does not show who shoots
Do you
first.
have a witness that says who shot
We
first?
do not have a witness, but we do have the placement of the shell casings. We do have the defendant firing at the victim while his friends are not taking cover. His friends are standing there. It's only about 10 seconds later that they duck down
So
behind
do we need to find that Rosello shot first? Isn't it enough that he threatened the use of deadly force?
Well, he didn't. It's not clear what exactly he did.
Well, whatever he
obviously
did,
had
it
the-
caused them to stop in their tracks, right? As you said, they were running towards him. They stopped in their tracks,
Yes.
retreated, and hid behind cars.
For a second, momentarily they did. But what's interesting is the victim keeps running across the street. And as he keeps running across the street, the video shows clearly that the defendant is crouched down, but the others that he's with are standing up. If there is a threat there, if Mr. Rosello was firing at that point, they would have been crouched down. They would have been crouching down at that point.
Again, it doesn't have to be that he was firing. It could be that he was threatening to fire, right? That he was aiming, that he was pointing. You don't have to wait for someone to pull the trigger to defend yourself.
Yes, that is true. But again, he's running away, and the people that the defendant are with are standing up. There's no threat there. They wouldn't be standing up if Rosello was in fact sort of running away and doing something like this. And he couldn't have been shot in the back. And all the shell casings confirm this. The shell casings that the defendant fired and the gun are recovered in front of the deli, and the other shell casings that were from the gun fired by Mr. Rosello are across the street and again, halfway down the block. And then after the shooting, the defendant takes the gun, passes it back to Cologne, who puts it in another garbage can, and then the defendant then high-fives someone in the group. In short, there's no reason to doubt the jury's verdict, and Justice Marcus, who tried the case, found the verdict was fully justified, so I would ask that you affirm. As to the ES point, these were, excessive sentence point, I'm sorry, these were defendant's fifth and
Wrap it
sixth
up, counsel.
convictions.
Thank you.
Thank you.
Actually, I meant you could finish your sentence if you want to talk about excessive sentencing. Just keep it short is all I'm saying. Go ahead.
Fifth and sixth convictions, second weapons felony conviction, and 20 years for shooting someone in the back, I think is eminently reasonable and not excessive.
Thank you.
Just briefly, Your Honors. Again, the mere fact that Mr. Rosello did not initially use the weapon that he had, the Glock 1003 that he pulled out, does not mean that he didn't threaten to use it. Again, the reaction of the people on the scene going back to the sidewalk, crouching behind cars, plainly shows that they understood him to have threatened the use of that gun. Respondent is also incorrect in claiming that thereafter the people that were on the sidewalk just simply stood around and didn't try to protect themselves. People's Exhibit 12, the video that shows a scene, starting from around 3:16, you will see that people on that side continuously kept themselves behind the cars to protect themselves. In particular, Mr. Colon, who was the original target of Mr. Rosello's ire, stayed behind the minivan the entire time. He was afraid of what Mr. Rosello was about to do and of what Mr. Rosello in fact did later on by firing 10 shots in his direction. So in that circumstance, Mr. Skeeter was justified in using force to defend himself and to defend others. And finally, again, the fact that Mr. Rosello was moving in the direction of Vice Avenue does not mean that he didn't threaten or use deadly force. He did, in fact, do so. And as I mentioned at the outset, if you look at People's Exhibit 8, which shows the location of the shell casings on the side of the street where Mr. Rosello was, you'll see that the shell casings span a fairly long area, indicating that as he was moving, he was discharging his weapon, his Glock 23, from that location.
And counsel, with respect to the bullets as opposed to the shell casings, the bullets were recovered from places near where Mr. Skeeter was sheltering, correct?
Correct, exactly. So there were 3 shots that were made that actually hit the window behind Mr. Skeeter and Mr. Colon at a height of about 5.5 feet, which shows that this was deadly force. Many shots were also made that struck the cars that were in front of Mr. Skeeter and Mr. Colon, again demonstrating that Mr. Rosello was using deadly force against those individuals. And if I may briefly touch upon the excessive sentence point, Your Honors, the sentence should be reduced in the interest of justice from 20 years in light of the plea offer that was made prior to trial of 15 years, and the fact that at the same time the prosecution has said that they were willing to consider a plea of 13.5 years. Respondent has now emphasized that the incident was serious, and Mr. Skeeter has a prior record but the prosecution was well aware of both the nature of the incident and Mr. Skeeter's prior record when it made the offer of 15 years. Here, there's no explanation as to why, at the time of prior to trial, when Mr. Skeeter was actually still facing a pending charge of second-degree murder, why after trial, where he was acquitted of that charge, a sentence of 15 years somehow is not sufficient to serve the purposes of sentencing. So in light of those reasons, this sentence should be reduced in the interest of justice. Thank you so much.
Thank you both. Global Leadership versus Commissioner of Finance.
May it please the court, it's Stephen Younger from Nixon Peabody for Appellant Global Leadership. This case concerns the revocation of a tax exemption for real estate owned by a nonprofit foundation. As a result of this revocation, the foundation has been effectively put out of business. The foundation was using this property for 3 reasons. 1, as a dormitory, 2, as a preschool, and 3, as a cultural center. All 3 uses are decidedly charitable. I think the critical issue is the burden of proof.
Could you just tell us what the date was of the, for the revocation of the actual use? Because I'm not aware that there was an actual revocation.
Yeah, it's at record 35.
What was the date, please?
It's dated December 7, 2016.
You mean the denial of the actual use application?
Correct. At that point, as the commission found, the foundation already had a full exemption, and it was removed according to the commission.
The full
And that-
exemption pertained to the contemplated
Correct.
contemplated use, right?
That's correct.
But there was never a granting of the application for actual use, right?
Yeah, that's what the Supreme Court relied on. The commission never addressed this issue, but there is no basis in the case law to distinguish between the two. And in fact, the distinction is one which would be devastating for the nonprofit community. People build.
Why is that? If the status of the applicant for the contemplated actual use is a not-for-profit, and the applicant for the exemption for actual use is also a not-for-profit, there should be no difference.
Agreed.
Here the allegation is that the application for the contemplated use was a not-for-profit, but the applicant for the actual use application had no such status.
Not true, not true. It was the same applicant.
Isn't there a distinction? Your adversary alleges that there's a distinction between an entity that is the Global Leadership Foundation and the Global Leadership Foundation, I believe is it LLC or is it Inc.?
Inc. That is only for the preschool. That is not for the dormitory, which is the principal use of the property. There's no argument whatsoever that there was any different organization running the dorm. In fact,
Well, let's talk about the dorm then. Yeah. How is it destined for use as a not-for-profit?
they concede that if you have dorm property that's for people of underprivileged means with
Was there any assessment as to the financials?
Absolutely.
Hold up, I didn't finish. Was there any assessment or ongoing assessment as to the financial resources of those students, not preschool students, but those students who would be using
dorm
the
residents.
dormitory?
Yeah. If you look at record 192, 400, and 449, they were screened for financial need, and they had to certify that they'd been enrolled in a school or an internship. And so the record was replete with
And the
proof of
rental rate for the dormitory units,
that. $500 to $600 for a single room, $1,000 to $1,100. I'm sorry, for a shared room, $1,000 to $1,100 for a single room, and there was a proof that this was below market. I think anybody knows. Try to get a room for $500 in this town. That's below market. I mean, you'd really have to stretch to find that this was, people of in luxury apartments.
so it's your contention that the Global Leadership Foundation,
Foundation.
Inc. was registered as a not-for-profit?
Not only was it registered as a nonprofit, but the IRS gave it a nonprofit grant of a tax exemption. That's undenied. And it's undenied that its mission is charitable. In fact, the commission found that the Department of Finance was wrong in determining that its purposes were not charitable. So the Supreme Court has created out of whole cloth this new exemption from burden of proof, which depends on the difference between a contemplated use and an actual use.
Counsel, now that we're getting back to that, the real property tax law has, it treats actual use and contemplated use differently. They're under different sections with different inquiries.
But the city has the exact same application form. You have one application.
That may
By the way,
that may be true, but you could have one application for two different sections.
you could have one application for two different uses, but there's no dispute that this was the same use. And if you think about how this works in New York City, nonprofits all the time apply for exemptions when they're going to build something out. If you then say that the same thing that they applied for now all of a sudden is not charitable, that would destroy the whole purpose of this exemption. You know, who's going to...
But there's two different entities at issue. They're not.
No, that's not correct, Your
They're not
Honor.
one and the same, are
That's
they?
that's not correct. It is there's no dispute. It's the same entity that ran the dorm, that applied for the dorm contemplated use. Exact same
Just
entity.
that one is incorporated and one is not?
No. You're confusing, Your Honor, the preschool. The preschool, there was proof that there was a Delaware entity that was running the school. That is not the case for the dormitory. The dormitory is one in the same entity, one in the same purposes, and they pulled the rug out from under my client. By the way, there's a second point here under the relation back doctrine. They admit now that Supreme Court was wrong, saying relation back doesn't apply to Article 78. The very case they cite says that Article 78 and regular actions are the same. So that alone is grounds for reversal because the Supreme Court got the statute of limitations wrong.
Counsel, wasn't the contemplated use here for a preschool?
There was a contemplated use for a dorm, for a preschool, and a community center, all three.
And that changed, right? From actual use.
It didn't change. It just, they completed the construction allowing them to run the dorm. And by the way, the very case that
Are you claiming a tax exemption based on the actual use of running a preschool?
Correct, yes, yeah. And by the way, the very case they cite, the Legion case, proves our point. Because the Legion case had two sets of tax years for an initial application. They put the burden of proof on the taxpayer. When they got to the second 2 years, years 2004 and 2005, they switched the burden even though they were both actual and contemplated uses. If they were correct that these are two completely different things, they wouldn't have switched the burden of proof because there was never an actual use exemption. That's the case that they cite from Westchester, which actually supports us. I think this whole distinction between actual and contemplated use has just been made up. There's not a single case that supports it. Every case that talks about revoking an exemption goes our way.
Thank you, counsel. You have time on rebuttal.
Good afternoon, Your Honors. Daniel Joy from the New York City Law Department on behalf of the Respondent Tax Commission.
Well, counsel, this whole discussion about contemplated use and actual use, is it made up?
No, Your Honor, it's not made up, and I think it's clear from the statutory provisions that there are different inquiries involved between actual use and contemplated use. In contemplated use, it's a good faith standard. The property is not actually being used for anything, but the applicant is saying that we have concrete plans to develop a property to then use it for an exempt purpose. Now, actual use is
Then when that comes to fruition, then you have to do the actual use.
That's correct, Your Honor. So at first, the contemplated use exemption is temporary while a property is being developed, and the standard there was outlined by the Court of Appeals in the Legion of Christ case, which talks about the very distinct and unique factual inquiry year over year when a property is not being used but is being developed to eventually be used for what the applicant says will be for exempt purposes. And there's actually a heightened scrutiny there because the Court of Appeals recognized a very important policy issue, which is we don't want land to sit undeveloped and for applicants to just...
So is there any inherent inconsistency with granting a contemplated use exemption, but then saying, when it comes to the actual use, saying you don't meet the test?
There's no inconsistency, Your Honor, and in fact, it's logical and it makes sense because under contemplated use, the property's not actually being used. When the property is then indicated to be in use by the applicant, which when the applicant submits the form to the Department of Finance and they check that the property is done being renovated and it's actually being used, that's the first time we're looking at the actual uses. And this is where it makes sense, is that this is the first time that we have, specifically as an example, when we're looking at dormitory housing, financial statements about how the property's run, marketing materials about how this is.
Let me ask you, if a contemplated use is granted and then an application is put in for actual use and the two uses are the same, then it should be granted as well, right?
No, Your Honor, not necessarily.
Why not?
And the reason is because when it's a contemplated use, the municipality doesn't have the opportunity to review the operational documents and other information what the property is actually being used for. So once it's an actual use, just because they had a contemplated use doesn't necessarily mean that they should have the actual use. And
But in that case, it seems that what you're saying is that when the government has an opportunity to actually look at the actual use, it's not what they said it was going to be.
exactly, Your Honor. And that's what happened here. And I want to correct something that Petitioner's Counsel mentioned. In the contemplated use application, there was no mention of a preschool, and that's an example. Then when they moved to actual use, there was an indication that they intend to use a portion of the building for a preschool. So we can see that there are differences between what an applicant might say they're going to do with the property and in good faith move towards developing it for those purposes, and then what is actually being used for once they fill out that application. So
I want to ask you about three areas briefly that pose questions for me. So your adversary says that there was an actual revocation of the petitioner's actual use application effective December 7th, 2016. Is that correct?
that is not correct, Your Honor. That was actually a denial of the actual use exemption application. And
And there is a difference between denial and revocation?
yes, Your Honor. So the burden of proof is on an applicant, unless it's a revocation. And the reason is because there's an important policy to, because exemptions remove properties from the assessment rolls and the tax burden shifts to all the other taxpayers, we have a heightened scrutiny when it comes to an applicant asking for an exemption. So it's important to keep that in mind. And I want to point out in the record.
I have two more questions.
Yes, Your Honor.
So the next question is of this. Your adversary argues that there is no distinction between Global Leadership Foundation and Global Leadership Foundation, Inc., that they're both not-for-profits. What say you?
Respectfully, Your Honor, and this relates to the 1617 exemption application, the Tax Commission wasn't satisfied with the proof that the petitioner submitted. So there was actually no evidence that they were the same entity, or at least it wasn't enough to meet the burden to show that they were the same entity. So they were incorporated in two separate states, one in Delaware, one in New York. They purported to be using the same federal tax ID numbers, but
They were also incorporated 4 years apart, right?
correct, Your Honor. So, and I see that my time has expired, but if I may briefly finish.
I have one.
Judge Gonzalez,
Oh, yes,
the
Your Honor.
third question.
My third question. Is it also true that you concede that there is a relation back provision that applies with respect to, it would be tax years 216, 17, 217, 18, 218, 19, and 219, 2020?
No, Your Honor, we do not concede that, and actually we say the opposite. In this case, the 2019/20 tax year, the petition was untimely filed, and it's our position that it doesn't relate back because it's a completely different application for a different tax year. And for the 1718 and 1819 tax year claims that petitioner tried to tack on in the amended petition, the only argument that petitioner makes is that it would be futile for them to exhaust their administrative remedies. It's undisputed that for 1718 and 1819, petitioner did not file an application with either the Department of Finance or the Tax Commission. And I just want to quickly point out that RPTL 420A subsection 11 requires an application to the Department of Finance in order to seek judicial review. And likewise, New York City Charter 163F requires an application for the Tax Commission to review
Thank you, counsel.
exemption
You make those
application.
points in your brief. Thank you very much.
Thank you, Your Honors.
So let me just make a few corrections. This exemption was not denied, it was removed. If you look at page R402, that's what the commission says. So you couldn't have something and then it just disappears. It was removed, meaning it was taken away. He says that on the second application, once it was actual use, they looked at what the property was done. That's completely fallacious. If you look at R35, all they looked at was the purposes. The purposes were exactly the same under the actual use as they had been on the prior use. Now, if they'd come along, they said, we actually built something completely different than we told you we were going to build, they'd have an argument. But if you come forward with the same purpose that you got your contemplated use for, and that's what the Legion case says, by the way, there's no difference. Let me just talk about relation back. He does not deny that the lower court made a fundamental legal error. They held relation back does not apply to Article 78. The Court of Appeals has said the opposite. So that alone requires a reversal here, because as the Supreme Court said, that was the best year in terms of the proof in this case, and yet he refused to consider it. I think the fundamental, and in terms of the GLF versus GLF Inc., he said there was no evidence. That's fallacious. Record 189 to 90, record 447 to 48 have an affidavit from my client saying they were one and the same and used the same tax exemption. But by the way, that's only for 1 year when we're dealing with a preschool. In terms of the dorm, this issue with the two different GLFs is completely irrelevant. So I think the fundamental issue is, how do you give somebody a tax exemption, say go build out something, and then say, oh, based on
Counsel,
the
with
exact-
respect to, with respect to the futility doctrine, is there record evidence showing that your client's applications for the 2017 and 18 and 2018 and 19 tax years contain the same facts as the prior application?
The record, unfortunately, is silent on that part. In terms of the first year and the fourth year, exactly the same. Exactly the same purposes. And all that you have is better proof of the application process. You have more proof in terms of, they filled the record with more stuff about how rigorous they were in the application process, so that Supreme Court said I'd have a tough time with this year if I considered it, right? But he chose not to consider it, erroneously saying relation back doesn't apply in Article 78. In terms of the futility doctrine, if you look at what Supreme Court did, he refused to even consider futility. That alone is an abuse of discretion. If at least you have to try to exercise your discretion. But I think what we have here is a situation where someone got a tax exemption, and then for the exact same purposes is told, now those purposes don't qualify, and had the rug pulled out from under them, which was not the kind of administrative standard we should be holding ourselves to.
Thank you, counsel. Thank you both. Lorne v. Lorne. You may proceed, counsel.
It pleases the court, Doug Barracks for the defendant appellant wife, Ludmilla Lorne. The lower court committed error in giving the husband a separate property credit for the various Schwab accounts. There, the burden of proof was on the husband to show that this property.
Now, it's clear that those Schwab accounts were never jointly titled, right, counsel?
That's correct, absolutely. But they were acquired during the marriage. And it was the burden on the husband to trace them to separate property. There was absolutely no evidence besides his own testimony and a self-filled-out net worth statement that he asserted that these were separate property.
Sworn statement not enough?
I'm sorry?
I'm sorry, sworn testimony is not enough to prove that up?
That's correct, unless it falls into several of the very narrow exceptions, such as if you have people who get married and several months after they're married, a large sum of money enters into the accounts that could not come from anywhere but separate property. Many years go by, the records are lost, and so forth. Here, this was simply, these were separate property funds. We were married in 1998, and based upon my testimony and a 2016 statement and a 2013 statement, it must be separate funds. Moreover, the husband admitted he did not know where the Schwab accounts came from. In his testimony, as I set forth in the brief, that I can't trace them. They may have been in the some before, after. I can't keep track of them. So the burden of proof, and this is the key error on the court, the burden of proof was on the husband to show that these accounts were separate. He failed to do so. And the court erred in classifying it as, as marital property, as a separate property. Those accounts should be considered marital property, and all the funds and all the other assets that flowed from them, including
Counsel, can you pivot to the 50 Madison Avenue rulings that were made?
I'm sorry?
And pivot to the 50 Madison Avenue issues that you raised in your brief about the apartment that they never lived in and the
Yes,
very
that's actually
long-running litigation on.
That's actually fairly unique to this case. For 50 Madison, the biggest problem here is that once the parties are divorced, the tenants by the entirety severs, and now they own it as tenants in common. Any other two people in the entire world would now have control over litigation for their interest in the property. There's absolutely no basis for the husband.
Well, there was a track record. Your client was in control of the litigation for some period of time, and it went on and on and on, and the husband is a lawyer, and wouldn't it be rational for the judge to find that he could bring it to a close?
If there was some sort of proof that it was the wife's fault why the litigation went on and on and on. The husband, who's a very seasoned attorney, admitted there were issues that were beyond.
Judge Gonzalez has a question.
How many lawyers were there
For
for the litigation?
litigation, I believe there were 3 lawyers, if I remember right.
Was it perhaps 4?
Maybe 4. That really wasn't.
Lawyers who had to start from scratch all over again, and wouldn't that have delayed the litigation as well?
That's true, but there was also 5 judges, numerous issues, conference issues, discovery issues. Unfortunately,
Well, the assignment of the judges has probably nothing to do with delay, right?
well, I believe it would, because a judge would also have to bring themselves up to speed. And if there were discovery issues, motion issues, and so forth, everybody admits this was complex litigation. The husband admitted that he allowed the wife to be the point person, the go-to person, deferred to her, deferred to her, deferred to her. The wife even said in the testimony is that she wanted to settle, but she would only settle if the husband would sign first. The husband's own testimony said that there were bad faith offers, that there were agreements offered that were absolutely unacceptable to him. The bottom line, though, of course, is that now that the property is by tenants in common, each person should have their own attorney. Now, you combine that with the wealth discrepancy between the parties and the fact that the husband essentially gets to take the legal fees, the bulk of the legal fees, off the top. The amount of legal fees for him, maybe a couple of months' income. Looking at the wife, it's years and years of income. He has absolutely no incentive, and you get a vindictive husband, a vindictive spouse following a divorce who wants to harm their spouse afterwards. It's set up to fail.
He's still on the hook for 40% of the post-commencement legal fees, is he not?
Yes.
So that is an incentive. That would be an incentive to sell. And also just to get this thing off your books, I would think would be.
I'm sorry, I didn't hear that part.
And also just to end this Jarndyce versus Jarndyce kind of litigation that was going on.
That is true, and unfortunately, the record on the was not really flushed out on this litigation, so we're left to speculate on a lot of things. However, the court can certainly take judicial notice that this case is going on. It's not resolving under the husband's tutelage, and that I believe there was an appeal recently. This case is extremely complicated, and there's absolutely no evidence other than the judge saying in the lower court, well, I didn't like the way the wife handled her case here. Obviously, therefore, she must be at fault in the 50 Madison Avenue litigation case. That's pure conjecture. To get that kind of relief, it was the husband's burden to show that she was at fault somehow, and he did not meet it.
Yeah, did the court err in giving him, I know your answer to this is going to be yes, 100% off the top credit for his payment for post-commencement carrying fees? Was that a mistake?
Yes, Your Honor. The simple reason is that his own interest should be borne by him. Any payments that he pays towards the wife should be borne by the wife. So what should happen there is that any post-commencement, assuming we keep the 60-40, he pays 60%, the wife pays 40%. He should therefore get back 40% of any post-judgment expenses paid. That covers the wife. She should bear that cost. Turning to maintenance briefly, the numbers in this case, this is a high maintenance case. Just for point of reference, the husband earns $12 million a year. The wife had no independent income. If you bring that down to more common numbers by taking 1% of the husband's income, the wife's award, I believe, comes to $784 a year. Now, obviously, you don't use the entire amount to base the maintenance award on. There is certainly a cap, I believe.
You don't take issue with it, maintenance continuing for 6 years, do you, in your papers? Okay.
No, the 6 years, but the number is grossly low. Doing the calculations, if the maintenance was increased to $75,000 a month, which in many cases would be astronomical, but not in this case, the husband would still have, after he pays taxes, after he pays all his expenses, he would still have about $3.2 million a year after paying the wife $900,000 a year for his own personal expenses. $75,000.
How much are we talking about per month that you seek?
$75,000 per month. It's a lot in an absolute sense. For this case, it certainly falls in there, and there's ample case law that I put in the brief. There was one case where a modest amount of maintenance was, I believe, $20,000. Other cases was $35,000 and so forth. This is not certainly out of line with this kind of income. One case, I believe it was, the income was $1.2 million, and it was $25,000 a month. Thank you.
Thank you, counsel. You'll have time in rebuttal.
May it please the court, Jed Greifer from Cohen, Clare, Lands, Greifer, and Simpson.
Should we start with the, oh, please, Judge Mendes.
With the maintenance, right now, how much maintenance was awarded? $7,500 a month?
It was $15,000 a month for 5 years, which has been completed. I'd like to point out that the request in the appellate brief by the appellant is not what was requested at trial. She requested an additional 2 years, not an additional 6 years. So this is procedurally improper that there's an increased request. More importantly, the amounts have no nexus to the expenses that were set forth in her net worth statement. It's not a wealth transfer, spousal maintenance. You need to demonstrate a need to meet your living expenses. With the $14 million or so of assets that she got in this case, she has ample resources to meet her own needs. There is no demonstration that she needs any support from my client.
The Westport and California properties were sold, correct?
They were not, I shouldn't say that. To my knowledge, they haven't been sold. If they have, it's something I'm unaware of. They certainly weren't sold as part of this record. She received both properties, and she received them at their appraised values, which, as we point out, the court can take judicial notice of what happens in the world, but, you know, she did well on those to receive both.
I'm not sure that's properly in front of us. Let's talk about the Schwab accounts, though, since that's where the other side started out. Your client said he didn't remember when the Schwab account was open. So is that problematic?
It is not, because appellant's counsel was mistaken. First of all, we did have in the record to show that the retirement account predated the marriage. That's at the record at 4191, which is his divorce from his prior wife, where this retirement account was listed in the divorce documents that relate to that California divorce.
Was there also evidence that there were no deposits made into the Schwab account during the pendency of the marriage?
We could not demonstrate account statements for each and every year because the account statements only went back to a certain period of time. But for every account statement that was available, we demonstrated that there were no deposits.
And how far back did that go? Was it 2013 or 11?
I believe 2011, but don't hold me to that. It's in the record, though. Additionally, my client explained that the type of retirement account to which he was allowed to contribute as a partner at Munger, Tolles, and Olson had changed. He went, I believe, from an HR 10 account, which no longer existed, to a different type of retirement account. So
when he returned in 1999.
Yes. So it's a different type of retirement account. So first of all, we don't have the burden of proof because it was a premarital retirement account. We are not, there is plenty of case law that testimony alone is sufficient, but we're not relying on just testimony alone. We've got the California divorce, we have the account statements for a meaningful period of time, and we have his testimony, and no contrary evidence whatsoever.
Should we go on to the 50 Madison issues?
Sure. So the court had ample indicia that this litigation had been mismanaged. Not only that, the appellant had taken completely contrary sworn positions as it relates to 50 Madison Avenue. During her deposition, I want to settle. Then the next sworn statement is, I will never settle. And it was being mismanaged. And as the court correctly noted, she had gone through a lot of attorneys. She had ruined relations with attorneys. But the matrimonial court also had the benefit of observing her litigation conduct in the matrimonial matter. I believe appellant's counsel is her 9th or 10th attorney, and there was innumerable delays in the matrimonial action, litigation misconduct. So the evidence before the trial court was not just limited to that which was adduced as it related to 50 Madison Avenue, but also within the matrimonial action itself was a very good proxy for understanding how the appellant was conducting the 50 Madison Avenue litigation and potential resolution.
Another part about 50 Madison that I asked your opponent about, was it a mistake to award him 100% off the top credit for his payment of post-commencement carrying costs?
Not at all, Your Honor, because those expenses are needed to save the property or preserve the property. It's no different than if there's a broker's fee at the time it's sold. It's going to be taken off the top, and it's a type of net proceeds that'll be left after. The entitlement is to the, let's call it the net value of the property. These expenses are being incurred to preserve the property. So no, they don't have to be allocated in proportion as to how the net proceeds are being shared.
Would you agree that there's a windfall to your client because he's representing them both in the litigation?
Not at all, Your Honor. He's not putting an extra dollar in his pocket. Whatever counsel fees he's paying is a dollar for dollar credit. He does not get an extra dollar or penny in connection with Judge Katz's order on that score. If I just may address equitable distribution.
Please.
So the court awarded a 60-40 split of the marital assets.
And the court has broad discretion in this area, correct, counsel?
That's correct. But the case law and the facts, more importantly, show that there are no contributions that this appellant can point to. She concedes she never contributed any monetary contributions. She didn't work. She didn't put any assets into the marriage. She didn't make any contributions to his career. In fact, as the evidence adduced at trial demonstrated, there were negative contributions. And in fact, during the pendency of the action, she affirmatively tried to get him fired from his position as the chief legal officer at his company.
Well, during the course of their marriage, though, she did help manage their properties, you know, and that's helpful to his career. In other words, she made sure that the Westport property was kept up, the California property was kept up.
I don't know that there was really much in the way of evidence of that at trial. She certainly lived at them, and I'm not saying she never did anything, but I think it would be an overstatement to say that she did anything meaningful in terms of keeping up the properties. Just getting back to his career, she didn't know who his boss was or even what the company did. She didn't know it was a hedge fund. She didn't make any contributions to family. She didn't raise children. They didn't have children. And in fact, she affirmatively interfered with his familial relationships. And in fact, one of his daughters had to flee their house in the middle of the night because she had been physically attacked by the appellant. And the parties, as the trial court found, were largely separated during the last 5 or so years of the marriage, during which there really couldn't be any contributions when a lot of this wealth was created. And the case law, not only cited by respondent, which demonstrates that a much lower percentage should have been awarded, even the case law cited by the appellant underscores that a lower percentage would be appropriate. In each of the cases cited by appellant, there are more substantial contributions than exist in this case. With my remaining time, I just want to address the issue of credits. This, I think, is just simply an oversight or administrative error, but what happened is you have accounts that are valued at the date of commencement. So if you know, there are many accounts, but if we just pretended for the sake of illustration that there was one account with $10 million and she gets 40% of that, she gets a check for $4 million. If he then used some of that money post-commencement to make a loan or to pay rent, she can't get another 40% of that because she's already gotten the 40% of the accounts themselves since they were valued as at date of commencement.
Would you address the issue, or did you already spousal maintenance, the $75,000 per month that's being requested?
I did. There's no nexus to her expenses as detailed in her net worth statement. She's demonstrated no need whatsoever, particularly given the substantial equitable distribution that she has received. And not only that, the time period is totally at odds with what she requested at trial. She can't invent a new request of spousal
What would you
maintenance.
say the equitable distribution should be?
20% of the marital estate.
Counsel, you can return to the credits if you want in your rebuttal.
Just to finish the point, so there was a...
No, I said you could do it on your rebuttal.
Oh, I'm sorry, I misheard you, Your Honor. My apologies.
No problem.
Just to touch briefly, the action was commenced in 2016. The claim that there were inordinate delays, the trial occurred in 2018. 2 years from commencement to trial with multiple motion practice, even with different attorneys who may or may not have delayed, shows there were no delays. That's an exceedingly fast time. As far as the wife's contributions, the fact of the matter is there were 3 properties, one in California, one in Manhattan, and one in Connecticut. The husband, he's out there making big bucks. I mean, $12 million a year, $8 million a year is low for him. Somebody had to manage these. That person was the wife. That's borne out by her testimony. We have the credits,
Yeah, let's talk about the loan to Ms. G. Teitelbaum. Why should she get 40% of that, credit for that?
Very simple. There was no proof that this was a post-commencement loan. There was absolutely
Couldn't
nothing.
the judge draw the inference given on what his salary was at that point? I mean, he was making a lot of money at that point, so couldn't you draw the inference that it was post-commencement income?
A simple check with a date on it and a bank account statement saying, here's the check, here's when it was made, this is post-commencement. There was nothing. So the record is absolutely void of when this occurred. And if it was the month before the commencement date, 2 months before, 6 months before, we don't know. The burden was on the husband to show, and it's really simple to do it. You get the bank statement, submit them into evidence, get the check. Ms. Teitelbaum could certainly testify, anything. We're just saying, trust me, it's on my net worth statement. So, and because my net worth statement says it's separate, and because I testify it's separate, they're both from me, therefore it's separate. And I have 2 pieces of evidence when actually there's none. As far as the Westport properties, the husband waived, Westport and California properties, the husband consented to the properties going to the wife.
I think that's not controversial.
Thank you. And for 50 Madison, we had the difference between the husband controlling this versus a third party is that, yes, this was a contentious divorce, but here we have the breakup of 2 spouses, 2 people who promised they would live together forever and take care of each other. And now to compare how that was litigated versus against a third party, which everybody agrees was a complex litigation, there's absolutely no proof that the wife was solely to blame. Thank you.
Thank you, counsel.
Just briefly on the issue of maintenance, I think it also bears mention that both parties are in their 70s, and the idea of maintenance is, to carry or tide a spouse over. There is absolutely nothing in the law. In fact, the law says the opposite, that you can't invade your equitable distribution even if it doesn't throw off enough income to pay for your support. You don't have to, as they say, die rich when you get substantial equitable distribution. As it relates to the loan to Ms. Teitelbaum, at first, appellant's counsel said there was nothing in the record, but in fact, there is ample indicia in the record. You have his original net worth statement, on which is proximate to the date of commencement, in which there is no loan, and then you have his updated net worth statement, which is required to be submitted at trial 2 years later. He has no advantage to suddenly disclosing a loan. He's just a truthful individual. It's dated. He could have been cross-examined about it.
It would have been easy enough to just produce the check, right?
He wasn't asked for it. There was no subpoena requesting it. There was no cross-examination. He met his burden. He affirmatively, through the court-required sworn statement of net worth, detailed what his assets were, and he had a loan receivable with respect to a post-commencement loan that he made, in addition to his testimony on the topic, not just his sworn statement of net worth. And then just to return to the credits, the other credit issue was that the court awarded a credit to the appellant as it related to a an investment or prior to the divorce, which the appellant acknowledges that she was aware of. It's part of the record. There's an email where she acknowledges there was no secret, no malfeasance, nothing sinister. Some investments do well, some investments don't, and it's bears mention, my client was also very generous to the appellant's family. He paid for her grandchildren's.
Counsel, I'm sorry, if you know, don't go looking for it. Do you know a record site for the 2011 email? Don't worry about it.
No, not off the
Okay.
top of my head.
There's a very big record in this case.
So anyway, there was no reason to classify this as some sort of waste. It was an appropriate expenditure 5 years prior to a divorce, so it shouldn't have a shadow of impropriety where a credit would be warranted. Thank you.
Thank you. Thank you both. ARC 56 versus Board of Managers. Give me a moment, counsel. You may proceed.
Good afternoon, Your Honors, and may it please the Court. Adam Hoffman of Lewis, Brisbois, Bisgard, and Smith on behalf of defendants' appellants. Appellants have asked this Court to reverse a number of rulings issued by the lower court. I'd like to focus on 4 of those today. The holding that the Board is deemed to have accepted an alteration agreement by performance, the holding that the Board acted in bad faith by disputing the enforceability of that agreement, the finding that the Board committed a fraud upon the Court.
The finding of the enforceability of the January 28th alteration agreement, that was made in what ruling by Judge Borak? Which?
That was made in the June 2022 decision.
Okay, thank you.
And the last point I'd like to address is the contempt of court holding. But I'll start with the ruling that the Board is deemed to have accepted the standard form alteration agreement for apartment units by supposedly performing under that agreement. That holding must be reversed for 2 reasons. First, as a matter of law, the Board cannot be bound by that agreement, which the Board never signed, because the recorded easement agreement, which was entered into in 2020, which dictated the terms that needed to be included in an alteration agreement for respondent's particular unit, expressly states that for all future work on or to the unit, the parties needed to enter into an alteration agreement executed and exchanged by the parties in a form prepared by and in substance satisfactory to the Board in its reasonable judgment.
One thing that animates this whole appeal is why weren't you satisfied by it? Because you'd already approved the daycare center in 2008 in the same space. And Judge Borak returns to that in all 4 of his rulings.
Since that lease had been approved in 2008, there were a lot of different agreements entered into that governed alterations of this particular unit. And the reason that happened is because around the time that that lease was entered into, the owner of that unit had performed all sorts of alterations that created a host of problems within that unit. One of those issues was that it rendered the building structurally unstable. So the subsequent owner to the owner that leased out the unit, which never actually built out the unit, entered into 3 separate agreements with the Board. There was the alteration agreement in 2016, there was a declaration of covenants, a recorded document, and the easement agreement, which was entered into around the time that respondent purchased the unit. 2 of those agreements, the easement agreement and the Park Ven alteration agreement, they contain the terms that need to be included in alteration agreements that govern alterations of...
I'm going to jump ahead, if I may.
Please.
Effective March 10th, 2021, the Board's architectural firm submitted a report to the Board finding that the plaintiff had complied with or was working on complying with the outstanding requests, and the PW1 could be approved. So what happened here? There were agreements, but it seems that the Board is picking and choosing between which agreements it will honor?
That's not the case, Your Honor. What happened is that
If the architectural firm engaged by the board said it's a go, what happened?
the board was, first of all, not aware of the scope of their architect's reviews. But additionally, around that time in March of 2021, actually April 2nd, 2021, the board learned for the first time that respondent had signed that standard form alteration agreement and immediately advised respondent that it had been given the wrong agreement, that was not the binding agreement, and it had paused the review. The board was not aware of, they had not reviewed the plans at that time. They were not aware of the scope, as I said, the scope of the architectural review.
I'm not going to say fault, but where does the burden lie then? You're telling me the board didn't do this, the board didn't know that, the board, didn't engage in due diligence? Is that what you're saying? And that therefore the plaintiff bears the burden of its failure to do that?
Your Honor, the issue with respect to the PW1 is that the PW1 form is the first step in the process for changing the use of the unit. And the board had not yet approved of the plans. The architects review the plans and they issue reports, but only the board can approve the plans.
But in 2008, during arbitration, the board, by its then current president, executed a PW1 form to change the health club's unit use to a daycare center and thereby amend so that the certificate of occupancy could be amended. I don't understand what you're saying.
In 2008, there was a PW1 signed by the board at the direction of an arbitrator.
We're talking about the same use, daycare health club to daycare. That never changed.
Correct, but the obligations that the unit owner had now did change as a result of those subsequent agreements. And the board, when the respondent asked the board to sign the PW1 form, the board responded that it would do so if respondent acknowledged its existing obligations and entered into an appropriate alteration agreement.
That was pursuant to the non-existent Eighth Amendment.
I'm sorry, what was that, Your Honor?
I was pursuant to the non-existent Eighth Amendment.
No, the proposed amendment had nothing. I'm not sure, Your Honor, excuse me, I'm not sure I understood the question.
Keep going.
So the board, when they were asked to sign the PW1 form by respondent here, they sent a letter from the board's counsel sent a letter that outlined the conditions that needed to be satisfied in order for the board to sign that form. And one of them was to enter into an appropriate alteration agreement because the board's position was that the alteration agreement that the property manager had provided to respondent, which only respondent signed, was not an enforceable agreement. And there needed to be an enforceable agreement in place before the plans could be approved.
Also, didn't the time for the board to object to the alteration agreement pass?
I don't believe that the time had passed.
Didn't they generally have, what was it, 30 days?
For are you referring to the time in which to respond to the request to alter the unit?
Yeah.
That's correct. That's a separate issue from the enforceability of the alteration agreement itself. So
I have to tell you that it seems like there's all this fluff being moved about, but isn't this very basic? 30 days to say yay, nay, or exercise a right of first refusal, a time frame in which there's requests for additional information, the court concedes that that's fine. And then another request, pursuant to what the board's own architect said, and then even after they responded that it's a go, it took how many weeks, how many months, not 30 days from there, to say, oh no, we want a new agreement. There was a mistake. We're rejecting it. New game.
Everything here flowed from the alteration agreement. The respondent returned that signed standard form at the end of January 2021. The evidence reflects that the board had no knowledge of that agreement until April 2021 and paused the review and insisted that there first be an enforceable alteration agreement that's consistent with the terms of the prior agreements that had been entered into with the prior owner, which are binding on respondent, before the process could proceed.
Thank you, counsel. You'll have time in rebuttal. Please.
Good afternoon, Your Honors. I'm Tracy Davis. I'm with the law firm of Seyfarth Shaw. I represent concurrent appellant Elizabeth Shrero. May it please the court, I represent a highly respected, long-standing member of the bar who has appeared before various courts in the state of New York for 40 years, and she has a stellar reputation. It's deeply concerning that she's been accused of committing, making misrepresentations and potentially committing fraud on the court. Before I proceed with our motion and our appeal, I'd just like to say that at no point in time has my client ever made any misrepresentations or false statements to the court.
Well, I mean, this is also a search for information, and as long as it doesn't search for privileged information, shouldn't she be subject to subpoena?
Well,
because she was a transactional lawyer. She helped facilitate the negotiations, and so therefore, you know, there's case law. She could be subject to an EBT and perhaps document discovery.
Your Honor, I think the record is fairly clear that Ms. Shrero is no transactional lawyer. She has advised and counseled and litigated on behalf of this client, whom she's represented for the last 37 years. She's also provided advice and guidance on this very litigation.
Yeah, I use the word transactional perhaps too broadly. I'm just saying that she did things that weren't necessary. They were part of negotiation. They were business rather than law.
Well, if you look at the authority, Your Honor, particularly if you look at Liberty Petroleum versus Gulf Oil, and the cases which follow that precedent, it's clear that it is not just counsel who appear in the litigation. It is counsel who provides representation and advice. The whole point of attorney-client privilege is so as to avoid that, provide that shield of protection so as to allow clients to get unvarnished, undisclosable advice. And that's exactly the kind of information that's being sought here. In making our application for a motion to quash the subpoena, we demonstrated not only that what was being sought was irrelevant to the issues at hand based upon the claims sought in the complaint. We also established the futility of taking Ms. Shrero's deposition, and that much, if everything that she would have to testify to related to attorney work product or otherwise privileged information. We also established that the respondent failed to demonstrate that the information was unavailable from other sources. And particularly in light of the procedural posture at which that subpoena was served. It was served after the lower court placed Ms. Shrero's knowledge and information at issue. She didn't volunteer that. The court ordered her to submit an affidavit asking her about not just one or two facts that may have been dispute. If you look at the court's order at what the court requested that affidavit contain, It literally asked for her to give her work product information on why the board took positions that it did vis-a-vis the letters that she wrote on behalf of the board, okay? To be placed in that highly unusual situation where the court is asking counsel who is advising a party on what the thought processes were in the board taking various legal positions that it did, not factual positions, but legal positions that it did, and then to have the court deny the motion to quash where what was really being sought was a deposition to further dig into that. This is clearly a case where the standard in liberty, which requires that an unavailability of other sources be shown in order for that deposition to take place.
Thank you, counsel.
Thank you.
May
May it
proceed.
please the court, Justin Bonanno for co-counsel for plaintiff respondent Park 56 LLC.
Counsel, what is the relevance of any information that you may obtain from the board's attorney?
The court below, and I believe one of the February orders said that at the time there was an issue of fact, and this ultimately was rendered moot when the court granted summary judgment. While that issue was pending, the court said that if the board is asking for something of Park 56 that it did not ask for from the prior unit owner, who in 2008 they'd approved the same use for the exact same unit, that would be prima facie evidence of bad faith. Ms. Schreier was intimately involved in that 2008 arbitration, which lasted about a decade, ultimately that prior unit owner went bankrupt and lost the unit, which is how we ended up with the unit.
But wouldn't the documents that they would have obtained from the board in discovery prove the same thing?
But we didn't get them. We asked for the documents. We didn't get the proposed Eighth Amendment that was completely relevant. It was more than relevant. It basically ended this case. So at the time, we were seeking that information from Ms. Schreier because we didn't get it in the context of party discovery. She was intimately involved in those transactions. She knows we were not, to the extent that if Ms. Davis believed that we were crossing the line of attorney-client privilege, she was free to object. The case law is clear on that. The Liberty case that she cites actually supports our position that an attorney that's not counsel of record. Ms. Schreier is not representing any of the parties in this action. She's outside general counsel for the board. She has represented them in the past. She may very well still be representing them, but she's not in this case. And those issues to prove bad faith were critical to this case. And if the case does go forward and we end up needing discovery, we will need that discovery from Ms. Schreier. And
If there's a straight affirmance, I guess it would be moot.
right, exactly. And that's what I was going to say anyway. Is ultimately if
Do you want to turn to the board's arguments?
yes, the alteration agreement is binding. Judge Borak got this exactly correct. We believe that Judge Borak was absolutely correct when he stated in his decision that this board will stop at absolutely nothing to prevent Park 56 from the use and enjoyment of its unit. And the evidence, the undisputed evidence and the undisputed facts, I believe, support that wholeheartedly. And in this 27-page decision that Justice Borak wrote, he cites threads, a 3,140-page record. There were, it was about 16 months of litigation before the final order was issued. Through that 16 months, there were 8 motion sequences, 6 hearings, obviously thousands of pages of documents exchanged. Some of the most critical ones were not. We found those on our own. The proposed Eighth Amendment, for example, which did not pass, was not a document that was produced. We found that on our own. And this is a full record. They had every opportunity to try to show the court below why their position is correct, why it is that they are now refusing to acknowledge that this alteration agreement is binding, not despite the fact that they provided that exact form to Park 56, both pre-closing.
So the Eighth Amendment that was not passed by the condo owners That came up only in the third set of motion practice, or was it finally, it was the final motion,
It
wasn't it?
was the final motion. We found it in June. It was actually my
And
client.
essentially, the defendants were using that, you said, and the court found, to say that the plaintiff had to pay for common element upgrades and that was not supported at all by the existing valid
That's
condo
correct.
documents.
That's correct. They tried to pass to pass that obligation in the proposed Eighth Amendment, and it did not pass. And then you fast forward 3 years later, Park 56 purchases the unit, and now it's so clear because if you look at the letters in the record from Ms. Sherrod dated March 16th of 2021 and April 20th of 2021, it's very clear that she's they were trying to pass that on as if that obligation existed when it did not.
Right. That was contained in one of Ms. Yarrow's letters. Did you just say that? I'm sorry.
I'm sorry?
The Eighth Amendment was quoted almost verbatim in one of Ms. Yarrow's.
That's correct.
But it was not ever passed,
No,
so couldn't be applicable.
that's correct.
So Judge Borak got pretty angry about that, just reading the decision.
Understandably so.
And he called it a fraud upon the court, did he not?
He did. We cross-moved for that finding in response to re-argument.
Also, with regards to the contempt,
Right.
what's the unequivocal mandate that the board failed to comply with that would subject them to contempt?
It was two things. One is they were refusing to consent to the change of use, which is in that February on the record ruling. The court held that having previously approved the change of use in 2008, nothing's changed. The exact same unit, it's the exact same use. There's no reason that they would be able to argue now that they can't, that they're not going to be able, that they won't approve it.
But
And then the second was the
were they
alteration.
ordered to approve it? Was there an unequivocal order, you have to approve this?
What the order was that, yes, essentially, it said that it was deemed, he's basically deemed it approved. He said, you will never be able to convince me that this should not have be approved now when you previously approved it back in 2008 and nothing has changed. It's the exact same use. And they've never established that anything's changed since then. The second part of the answer is the alteration agreement itself. The court said the alteration agreement is binding, so they have to perform pursuant to that binding alteration agreement. They did not do that. After the June order came down, number one, they initially said they would sign the PW1 if we made some changes to it. We did make those changes. We sent it back, and then they declined to sign it at that point. At that point, they brought out a third engineer's report, the same engineer who in March of 2021 said that everything was fine. Now, all of a sudden, nothing's fine. This engineering firm basically reversed themselves. And, there was no explanation for it. There were things that
You know
were...
that with respect to contempt motions, the court is generally cautious, right?
Of course.
And it's very detail-oriented. So if you say, for example, pay this money, it's different from saying pay this money by a date certain, right? So here, there was no specific directive that the PW1 be signed, am I right?
It wasn't specific in those words, but it was specific in the sense that there was an alteration agreement that was deemed
You have
binding.
to infer it from the order, correct?
Right. But that's correct.
Thank you, counsel.
Thank you, Your Honors.
You've got 2 minutes rebuttal.
Thanks. I'd like to address the fraud upon the court finding. A central issue and dispute between the parties here was who would be responsible for covering the costs of impacts to common elements necessitated by respondents, alterations, and change of use of its unit. And the board at all times has relied upon the easement agreement and the park ven agreement that are binding only on respondent as the owner of its particular unit in identifying respondent's obligations. The proposed amendment would have clarified that all unit owners have that same obligation.
You're talking about the Eighth Amendment?
Correct. The proposed
It doesn't exist. I mean, it exists on paper, but it was never passed.
Correct.
And how could you impose obligations on anyone pursuant to an amendment that was never passed?
The obligations that the board relied upon were not in the declaration. So the fact that the
So where were they? They weren't in the
They were-
Eighth Amendment, they
they were
weren't in the deck.
in the easement agreement and in the park ven agreement, and we identified the provisions in our brief from both of those agreements that contain broad obligations on respondent to cover those costs. If there were no easement and there were no park ven agreement, and the board had relied only on the declaration in saying, respondent, you have these obligations, and they had withheld the proposed amendment that didn't pass, then respondent would have a good argument. But the board was not relying on the declaration, so the proposed amendment that would have clarified the terms of the declaration had no bearing on the issue here. It's about the obligations that are binding only on respondent as the owner of this particular unit. And with respect to the contempt of court, there was no unequivocal mandate that the board sign that PW1 form. The court had held on the record at a February 2022 hearing that the board could not exercise its business judgment not to approve the change of use. But at the same time, the court said that the board could certainly articulate its concern with the plans and ask respondent to act reasonably in addressing those concerns. The board interpreted that ruling as saying that the board needed to sign the form once the plans were approved. Thank you.
Thank you, counsel.
I think I get 1 minute, right?
You have 1 minute,
Yeah.
that's correct.
Counsel, did your client make reference to the non-existent Eighth Amendment?
I'm sorry?
The letter. Was there a letter where your client made reference to an amendment that had never been approved?
I don't believe so, Your Honor. I don't. Because as my co-counsel has articulated, the proposed Eighth Amendment really had nothing at all to do with this commercial unit. It had everything to do with those other units to which the easement, as well as the other governing documents that are specific to this unit, controlled. So there was no need to talk about the proposed Eighth Amendment. Therefore, there's no grounds for the court to ever find that failure to disclose it was somehow or another constituted a fraud.
Or the mischaracterization of it?
Well, I don't think that it was mischaracterized. I think that what's gone on in this case throughout is that rather than evidentiary fact-finding happening where witnesses who have firsthand personal knowledge are provided with the evidentiary basis upon which the court issued its decision, the court instead relied upon oral argument on motions to establish some of what the court believed, I would argue erroneously so, what the underlying facts were. But I just want to make one point as to the discovery issue. This case is at a procedural posture unlike any. There were 2 summary judgment motions in an action where the first partial summary judgment motion sought essentially the entire relief that was sought in the complaint, i.e. a declaration as to each and every one of these issues that and understandings, obligations that have come up. And there was only minimal amount of discovery that was done. The subpoena that was served on my client was served before there was any party discovery. I'm sorry, there was any party depositions. And so, you know, I think that when counsel says that, you know, they established a prima facie case that what happened in 2008 should have been abided by, in 2020.
Counsel, we're going a little bit far from your cross appeal. I mean, your
I'm
appeal.
sorry, you're right. But I'm just saying that my client's understanding of what transpired really was related to that. So thank you.
Thank you very much. Thank you all. People versus Giovanni Neves. Give me a second,
afternoon.
counsel. Hold on. Thank you.
Good afternoon, Your Honors. Legal aid.
Hold on a second,
Oh, I'm
counsel.
sorry.
Just a minute. Thank you. Okay, you may proceed.
Thank you. Legal Aid Society by Catherine Pecor on behalf of Mr. Nieves. Mr. Nieves' 7-year prison sentence was excessive and unnecessary, where at the time of the offense, he was 35 years old and despite struggling with untreated polysubstance abuse since childhood, had no criminal record. And in fact, despite...
The victim here suffered a fractured skull, brain bleed. The injuries are not insignificant. They're
No.
actually very serious.
That's correct. And, you know, the facts of the offense are not disputed. This was a very serious offense. It's an assault in the first degree. And that's likely why Mr. Nieves had to plead to the top count of the indictment. You know, he didn't get some great deal. This wasn't a humongous windfall to him, but he pled to the top count.
He did face 25 years, right?
Yes, Judge. But, you know,
Counsel, was there an implement used in order to inflict the injuries?
it was a metal pipe or some type of metal object, I believe.
And how long was that pipe? How long, was it a big pipe, a little pipe?
I'm not sure, Judge. I don't have that information at my fingertips. But yes, undisputedly, this was a very serious offense. But I think it's really important to look at all the other factors that go into sentencing. And every aspect of Mr. Nieves' life really reflects that this was an entirely out-of-character, aberrational offense. And really the root cause of it is this drug addiction that he's struggled with his entire life.
Wasn't that information before the sentencing court?
Yes, Judge, it was.
And it was also before the plea court, which was the same court. So they knew about his drug addiction and all the other things that you're mentioning.
That's correct. But as this court is aware, it does have the power to reduce his sentence in the interest of justice. And I think he's exactly the sort of candidate who deserves a sentence reduction.
I guess my question is, why reduce this sentence in the interest of justice? This is an attack on a subway, right?
That's correct, Judge.
And somebody who was just there?
Yes.
Was there a provocation? Was there, like, anything going on?
So it seems as if the complainant made some type of derogatory comment toward Mr. Nieves. He's panhandling, asking for money. He's really at a crisis point in his life. And of course, that doesn't excuse it.
He's what?
He's at a crisis point in his life.
Crisis.
He's under the influence of 4 different drugs at the time. That's going to have an impact on someone's mental state and impulse control. And again, this is not to excuse, but it's sort of to lay the groundwork. This is someone who had just relapsed after 8 years of sobriety, which he achieved without any treatment, actually. And he was living in a shelter with his family. He had 2 very young kids at the time. He was making no money, and he tried to head this off. He actually went into detox shortly before this.
Also, our interests of power, our powers, aren't they extinguished by the waiver of right to appeal?
No, Judge. So this waiver is pretty clearly invalid for a number of reasons, but on a high level, as this court is aware, it has to be clear on the face of the record.
So your client was asked again and again when he was unclear as to what his response was. Judge paused, right? The judge paused, asked him again, and asked him, does that mean a yes? Didn't all of those things happen?
Yes, but the important distinction there is that those exchanges happened during the plea colloquy, not during the waiver colloquy. That concerned whether the plea was voluntary, whether he was sure he wanted to plead. The judge was very careful to inform him, you have a right to go to trial, etc. But I'd ask the court to look at the appeal waiver colloquy, which is reproduced in its entirety on page 14 of our reply brief. And what that consists of is the court giving a very long, kind of convoluted explanation of the waiver. Mr. Nieves interrupts. He says, I don't know why. The court says, sorry. He says, it's all right. And then the court picks up in the middle of the sentence. So that's the only exchange that happened during the appeal waiver colloquy. But, I think the rest of the colloquy really illustrates that Mr. Nieves was confused about a number of things. He didn't really seem to understand fully what was going on. He interrupted a lot.
Also, there was a written waiver here as well, right? But I think that the record bears out that there was no colloquy with regards to the written waiver.
That's correct, Judge. I believe it was mentioned sort of as an afterthought on the last page of the transcript. The court officer says, oh, by the way, he has to sign the written waiver.
But the court didn't inquire whether the defendant had read it, whether he understood it, whether he had any questions.
Exactly, and I think that's really key here, because to the extent the oral colloquy was unclear, the written waiver really had a lot of power to sort of clarify that, but we don't know if he read it. We don't know if he went over it with counsel. We don't really know if he signed it, but even if he did, there's no indication he understood it.
Thank you, counsel. Did you have a question?
The next one.
You may proceed, counsel.
Good afternoon. May it please the court. Megan McLaughlin for the people. I just want to make a slight correction for the record. As this court already noted, among the number of times that the court did inquire as to whether the defendant was understanding the proceedings that were happening, the judge did ask directly after the appeal waiver explanation, do you understand what I've just said? And the defendant stated, yes, sir. So he did confirm that he understood everything that was happening, including the waiver of his appellate rights.
I want to know, is this sentence excessive given the nature of the injury to the complainant, to the victim in this case, and the sentence that the defendant received, which was about 2 years above the minimum?
No, Your Honor. Notwithstanding the valid waiver of his right to appeal this sentence, the sentence was not unduly harsh or severe given the very severe injuries to this victim. As was already discussed, he took a metal pipe and struck the victim, actually fracturing his skull, fracturing his eye socket, and causing a bleed to his brain. So these were, as the court has already noted, extremely serious injuries that ultimately resulted in extremely serious pain for the victim.
How do you respond to your adversary's position that this defendant had unfortunate circumstances, including drug addiction, being homeless, and et cetera?
Those circumstances were likely the principles behind the court's decision to not only sentence the defendant only 2 years above the minimum for an extremely serious assault.
What were the people asking for in this case?
So that's actually not in the record on appeal, but it is clear from the record that whatever the people did recommend was undercut by this. So the people had been asking for higher than 7 years, and the court, in conjunction with the defendant's willingness to plead guilty and the defendant's willingness to waive his right to appeal, was willing to undercut the people's recommendation and give the defendant only 2 years above the minimum for this extremely serious attack.
Exposure being 25 years.
His exposure being 25, yes, Your Honor.
This is the defendant's first felony, correct?
Yes, yes, Your Honor. And that was presumably taken into account in this sentencing decision.
And his family condition and all of the other things, his drug addiction, all of that was considered when the offer of 2 years above the minimum was made?
Yes, Your Honor. The sentencing court had the defense expert plea report that detailed everything that defendant details in his appellate brief, which were all of the information regarding his family history, his drug abuse, and a journey through treatment. So all of this information was before the sentencing court, who ultimately determined that 7 years was an appropriate sentence for the crime. If the court has no further questions, the people will rely on the brief.
Thank you, counsel.
Thanks.
So, Your Honors, I think it's worth noting that, as this court is aware, the purpose of punishment is not only to deter and not only to incapacitate, but also to rehabilitate. And I think what's key here is that Mr. Nieves has proven that he doesn't need a sentence of 7 years to get him on the right track. Especially noteworthy, while his case was pending, he completed a very intensive and rigorous drug treatment program. This is not an easy program. It was a zero-tolerance, strict rules program. He did amazingly well. And I think that shows that he is independently motivated to recover and address what was going on in his life without the need for a sentence 2 years above the minimum. And remember, this is someone who was first introduced to drugs, hard drugs, when he was 12 years old. So this is a very, very tragic case, and he had an uphill battle from the start. But he's also someone he's never resisted treatment. He didn't just come to court and say, okay, I'm ready for treatment. He's been trying to get sober his entire life. He went to rehab at one point, but mostly he just tried to abstain on his own and was successful in doing that for quite some time. So I think it's not really lip service about wanting treatment. This is something that he's really determined to do, and I think that's really important in this court's consideration of whether 2 years above the minimum is necessary. Thank you.
Thank you, counsel. Thank you both. Okay, Kanzansis. Okay, counsel.
Good afternoon, Your Honors. May it please the court. Eric Blaha from the law firm of Smith, Buss, and Jacobs on behalf of the appellant, George Kazantzis, as executor of the estate of David N. Edelstein. Your Honors, I believe this is a case of first impression where you have a borrower on a reverse mortgage that is the estate of David N. Edelstein.
Counsel, if you make that argument, if the estate's the relevant borrower and it has a continued right of possession through September 30th, 2065, what's the meaning of maturity event in the relevant documents? I mean, why have maturity events?
Your Honor,
you're saying that we get this place until 2065.
Your Honor, that's an
sense?
excellent question. We didn't draft the documents. This is a lender who is putting together a document that doesn't fit. They created the definition of an event of maturity. Their events of maturity are threefold. It's a conveyance, it's death, and it's what's the third? The
Ceasing to use the apartment.
ceasing to occupy.
Right.
Okay, occupancy was conveyed by a proprietary lease. Your Honors, this case is not moot. There was an initial sale at the foreclosure that the judge let happen. That deal fell apart.
There was no one occupying the apartment, right? Because the owner is not a human being.
Yeah, but the owner wasn't a human being at the time the loan was created.
Did the estate become human?
No, it never did.
Okay.
But then that's the problem with the loan document, not the problem with my
client. The argument to that is that there was a maturity event upon signing.
Your Honor, I appreciate the catch-22 here, right? But we didn't create that, okay? This is a document that was created by a lender before the laws that were passed last year, okay, permitting reverse mortgages on co-ops. Previously, there were no protections from predatory lending. Now you have things that are in place as of 2022 that presumably would prevent a situation like this where you have oversight and regulation.
Not moot. I mean, hasn't it been sold?
That's a good question. That initial deal that's referred to in the papers fell apart. The board did not approve the buyer. There was a second foreclosure sale at auction. The bank credit bid.
The question is, if the apartment has already been sold.
It has not been sold.
I mean.
That's my point. Is
wasn't it sold on August 5th, 2021?
That the board never approved that sale, so that deal fell apart. The bank, the lender, then conducted an additional sale at which there were no bidders. The bank
and it
took
bought it itself.
The bank credit bid is now holding the stock and the lease. Okay, so that the stock and the lease is still in the name of the estate of David N. Edelstein. So this court should reverse. Okay, and at that point, there's no undoing, there's no unraveling, there's no prejudice here because the lender is still in control.
Counsel, but also, what's the irreparable harm here? I mean, isn't this just a financial deal? The corporation, if it is the owner, if you want to reify it that way, it's never going to live in the apartment. It doesn't need this unique piece of real estate. It's a financial deal, so they can get money damages. Therefore, no preliminary injunction.
Your Honor, respectfully, This is unique real property. It's well-established law in the state of New York. It doesn't matter who's living there or who's not living there. This is real property. It's treated as real property, and you wouldn't be asking that question if we were talking about a single-family residential home.
Yeah, because the single family might have some emotional attachment to the house. How does it, okay, I'm sorry, you take my point.
Thank you for your comments. I appreciate that. But on the other hand, okay, taking that into consideration that this is real property, okay, it's treated as real property. What's the balance here? What's the alternative? The bank has only a financial interest here. The bank has an argument that can be this is a money only argument. I'm sorry, if you'll allow me to finish.
No, please go ahead. If it's a money only
depriving-
argument, you mean only for the bank it's a money only argument? And for you guys, it's what?
It's unique real property. This is well-established law, Your Honor. And it was that way at the date they took the property in 2008. The estate is the owner, okay? The estate, nothing has changed since the day the estate took ownership. They still are the owner. They still have the right to occupy. They still are on the stock and lease. They still are the estate is the borrower. The estate is the borrower, not an individual that dies or doesn't die. The bank knew this. These are the bank's documents. They're stuck with their own documents. And this court, respectfully, Your Honor, and the lower court should not have rewritten the loan documents for the convenience of litigation.
Thank you, counsel.
Thank you so much. I really appreciate the opportunity to speak with you today.
Okay, the last case we have is Pearlbinder Holdings versus Patel. You may proceed, counsel.
Good afternoon to the court in this long session. May it please the court, my name is Mike Curran. I'm a solo practitioner from Flushing, and I represent the Patel family on this appeal. And I promise to the court, this won't be a Jarndyce versus Jarndyce type of proceeding, and I'll avoid doing my best impression of Mr. Tulkinghorn. In any event, unfortunately, there are some serious issues involved. My clients have been abused by CPLR 3213 because they've been found liable on a non-existent guarantee dated January 20th, 2016, which appears in the record in the sworn affidavit of Mr. Pearlbinder, Barton Pearlbinder by name, in the record at A22 to A27, where he states there was such a guarantee January 20th, 2016, but it doesn't exist. In his brief, the respondent tries to turn things on their head by claiming we created this mystery guarantee, but it wasn't us. Mr. Pearlbinder swore on August 28th, 2019, that there was such a guarantee. And by the way, there's a cross-reference at A161, paragraph 3, where the January 2016 guarantee is also referred to, and there's also a lease modification dated January 20th, 2016 at A122 to A130, which was entered into by Mr. Pearlbinder, dated again January 20th, 2016. But there is no guarantee from that date.
So on December 1st, is that the operative date? The guarantee was on December 4th?
December 16th.
I can
December 4th, 2015.
I can help you with that.
Help me with that, because I see that there was an assignment of lease on
Right.
December 1st.
There,
Then the guarantee was signed purportedly on the 4th of December?
There were a package of documents that were dated December 16th, 2015, appearing at A113. But no possession ever occurred until January 20th, 2016. My clients never took possession until a month later. And what happened was...
But counsel, there's really no dispute that there was a guarantee that was executed by defendants on December 16th.
But it was superseded, Your Honor. What happened was...
Superseded by what?
Well, let me tell you. there were 2 lease modifications by the original tenant, Jackson Peng, who was the original tenant from 2012. He executed a lease modification in December 2015, and then he did one in December 2016 that superseded the first lease modification of 2015.
The problem here, though, is the language, the unconditional and absolute language of the guarantee, right? Which says that it cannot be, it shall not be impaired or affected by any amendment, extension, renewal, modification, or assignment of the lease. That's awfully broad language, isn't it?
Well, you see, Your Honor, but there was no replacement of that guarantee. What happened was the lease modification, which governs, because in paragraph 9, it states if there's any conflict between the lease and this lease modification, this modification governs the transaction. It says it right in that document, which is at A122.
That may be true, but how does that affect the guarantee, which is unequivocal in that it's not affected by modifications or amendments?
They forgot to execute a new guarantee, Your Honor.
Why would they need to do that if this
Because-
guarantee itself says that it's not affected by future renewals, modifications, or assignments?
Because the transfer never occurred in December, Your Honor. It happened in January, and therefore that guarantee didn't apply to anything. The December guarantee didn't apply to anything. There was supposed to be a new guarantee that shows in the record, and it wasn't executed. It was a mistake. The respondent made a mistake, Your Honor, and then swore in an affidavit on summary judgment in lieu of a complaint that there was a guarantee from January 20, 2016, because they forgot to make one. That's what happened here, Your Honor.
So I'm looking at the record at A35, where it references the assignment, and it says at paragraph 24, however, notwithstanding the foregoing provisions and so on, the liabilities, where is this? Everything remains in full force and effect, and that's what the document that says January 2016 also says, that the Asinor guarantee remains in full force and effect, notwithstanding the assignment of the lease to Asini. All the documents are in concurrence.
Well, let me just say this. The tenant was Jackson Peng. He was from the November 2012 lease. He signed a lease modification in December. He also was involved with these other documents. But then in January 2016, my clients actually became the tenant. They took possession then, not in December, in January. And that's when the guarantee should have been executed, and it wasn't.
Thank you. You've got time on rebuttal, counsel.
Thank you, Your Honor.
Thank you.
Let's see this again.
Good afternoon, Your Honors. My name is Howard Grun, Kaufman, Friedman, Plotnicki, and Grun. I represent the respondent.
Counsel, did you make a mistake? Did you have to execute a new guarantee in January?
No, and in fact, it's paragraph 5 of the December 16, 2015 guarantee that Your Honor was referring to in terms of it being in place and solid forever, whatever may have occurred later on. And it is very broad, and it's meant to be that way because there are a series of transactions here, 5 amendments, and you'll notice in each one at the end, his client signed off that the guarantee without a date, the guarantee is in effect and remains in effect. And even if there was some mystical January 20th, 2016 guarantee, no one's produced it. I think it's with the 8th Amendment in the Park Vendome case, Your Honors.
Oh, don't go there.
But frankly, it doesn't exist. And you can't ground your entire appeal in a non-existent document. And even if it does exist, there's no proof that it superseded the December 16, 2015 guarantee. And those are very broad. And frankly, if counsel's suggesting that the documents were somehow re-signed in January 2016, he's not suggesting the terms were any different than they were in 2015. And there's no suggestion here that the money was paid or was not owed. So what we're having here is a vast conspiracy that's being alleged in the papers about all the parties getting together and somehow making a mockery of his clients and changing up on their liability. It doesn't exist. This is just...
So let me ask you, is there any way to break, void, change the guarantee? Because I don't see it.
Is there any way to?
Because the language is so comprehensive.
Yeah, I think you would have to have a superseding guarantee that says the guarantee of December 2015 is now void and replaced by this guarantee. Without that, any guarantee that's signed, it could be supplemental to a second guarantee. There may be a second guarantee that was signed that doesn't void the first, so now there are two guarantees. My client signed an affidavit, and Exhibit A was the guarantee he referred to as the one that was the guarantee in this case. And it is the only guarantee that's produced by anybody in this litigation. So if there was a typo in the papers, that does not mean that the guarantee, which is an exhibit to the papers, is somehow now voided. And we made that clear when we submitted our proposed judgment to Justice Marin. 3 Supreme Court judges went through this and reviewed it and found no problem with it. We're not in a gotcha situation here, Your Honors. We're trying to litigate and preserve people's substantive rights.
The adversary says you have a service problem.
Well, this court actually resolved that service problem to my client's benefit in a different litigation involving the same parties. I've cited it in my papers. Service was made in both cases at the same time, and that claim was rejected by the lower court in the other case and rejected by this court on the appeal. So they were stopped, I think, from arguing that, and all of the rationale that this court stated in the prior litigation applies equally here.
Thank you, Counsel.
Thank you, Your Honors.
Please, you have 1 minute.
Yes.
So I'm going to ask you the same question, but in a different way.
Go ahead.
Because a lot of times I don't like these guarantees, but I see what they say, and parties agree to be bound by them, and that's that. So with this guarantee being as comprehensive as it is, how do you possibly bypass it? How do you get around it? It doesn't have to be renewed.
Well, let me say this. Guarantees must be strictly construed. Is that correct?
We get to ask the questions, Counsel.
I'm sorry.
Yes.
Well,
That was a rhetorical question.
it's a rhetorical question. It's a Tulkinghorn question. But anyway, the guarantee was for the transaction that occurred in December 2015. Now, it doesn't say that, but at that time, Jackson Peng was a tenant and he was turning over the premises. But he never did. He did it the following month. So that guarantee became totally irrelevant. A guarantee can't be a freestanding.
The word assignment is included in this.
Yeah, well, these documents were floating free. They were not properly replaced. If you look at all the lease modifications, they all refer to a January 2016 guarantee throughout the 5 modifications that Mr. Grun has just mentioned. I like Mr. Grun, but there was a mistake made. I don't know who did it, but there was no tenancy until January 2016. You can't apply a guarantee to a non-existent relationship.
Thank you, Counsel. We have your papers. Thank you, Counsel.
Thank you.
Have a nice day.
Thanks. You too.